we've been provided with some additional documents. Justice Parker's order, Deborah Eaton's order, Miss Justice Roberts' order, Miss Justice Moore's order, and the missing pages from the Form E. So thank you for those.
Lord, I hope those are helpful. Can I provide you with some more information that Lordship's asked me about this morning? One was the question of who the remainder man of the Lady Mary Berry Trust wills are, and the answer is not as we thought, but Mr. Villiers' children, or his child. It's not in the bundle, and we can provide it if necessary, but I don't suppose it's contentious.
But was that, wait a minute, isn't that what, as my lord pointed out, is what's stated in the judgment? Am I thinking about the wrong one?
Well, there are two remainder people. One is under the father's will, and one is under the mother's will. Perhaps I misinterpreted the question, but
sorry, I'm just trying to find it in my notes, and I've now.
The paragraph I referred to was 68.1.
Is that the one we're talking about, Mr. Capert?
I'm sorry, my lord. What was
is it it's the grandchildren's fund?
Yes.
Yes, and that's what's set out. Clarissa is the capital beneficiary of the husband's share.
Yes.
Yep. Okay, that's right.
Yes, that's right.
Thank you.
Yes. And my lord, the other question was as to the value of the other trust and whether there are any references in the bundles to that. Your best reference is not perfect, but the best reference is at B417 of the supplemental bundle. Which gives probate values for the estate, because bearing in mind that the net probate figure of the estate in 2004 was 7.55 million, and it comprises a majority shareholding in the Chilworth Trust Company, which owns the house in Notting Hill, in the accounts at £282,000, cost in 72, understood by the wife the contracts have just been exchanged on the property at 9.7 million, and she says that the estate may not be limited to that asset. In fact, our researches show that it's been sold for 8.7, 8.9 million pounds. Our public researches.
Thank you. Yes.
Can we just return for a second to the question of section 27.3? Your Lordships kindly pull it up.
Yes.
I'm not sure I made the point clearly enough in this morning, but reading 27.3, application under this section made on the ground mentioned in 1A above, then in deciding whether the respondent has failed to provide reasonable maintenance for the applicant, and B, what order, if any, to make under the section in favour of the applicant, the court shall have regard to the section 25 factors. I know I did make the point, but in case I didn't make it properly enough, one of the factors that this court must have taken into account, or should have taken into account, was the situation in 2013. This court having decided that the circumstances in 2013 were germane to whether or not the provisions of the section were satisfied. What this court did was decided that a 2-year period was appropriate, and that means 2013-2014. We know now, but we didn't then, that during 2014, during the husband's bankruptcy, he did do some work. He disclosed some bank statements with his second Form E, and they show payment in. And we argued in front of Mostyn J that that was sufficient to show that there was economic activity that would have justified some sort of order, and he rejected that argument. But what he didn't do is look at 2013 at all. Having set himself the task of examining 2013 and 2014 as being his period of analysis, he didn't do anything in respect of that, and that's because nobody asked the husband to disclose anything from 2013, quite apart from anything else, which goes back to this question that we mentioned this morning as to what an appropriate period would be. But in terms of the task that this judge set himself, he should have done the task of examining whether there had been a willful failure to maintain during 2013, and then failed to deal with that at all, mostly, to be fair to him, because he didn't have any material going back to 2013.
So how was he supposed to perform the exercise if you concede he didn't have any material?
Well, that's my point, my lord. We didn't concede that the 2-year period was appropriate. What we concede is that he didn't have any material for 2013. We say it didn't matter. We say that wasn't the point. The point was that one should have looked at it from 2015 onwards, in the here and now, under Section 25. But having set himself, our point is that he could not have done. He set himself an impossible task, which shows what an unfortunate and unsatisfactory test it was that he set himself, and shows how the arbitrary...
Well, I understand your proposition that he's proceeded on a wrong construction of the statute, but is there some independent complaint being made? Because if so, I'm completely unclear as to what it is.
My lord, the complaint is that he failed to do what was required of him under Section 27.3, which is that when you're considering an application under...
But your complaint there is you say he should have proceeded up to the date of decision.
Yes.
Rather than imposed a cut-off point of January 2015.
Lord, precisely,
and if you're right about that, you're right. Mm. And if you're wrong, you're wrong. But how does his failure to have regard to the position in 2013 bear upon that either way, particularly when you accept he didn't have the material?
Because, my lord, the test that he set himself was a bad test. And it was an inherently bad test because, as we know, he wasn't able to satisfy that test. He should never have set himself that test because he, as you say, he didn't have the material by which he could judge whether or not there'd been a failure.
All right, but can I ask you this question? Bearing in mind that we've seen from your client's statement in support of her application that she was basing herself upon the period 20th of August 2012 to 13th or 14th of January 2015. Now, if he had asked himself whether there was a reasonable failure to provide maintenance in that period, because we know there was no maintenance provided, that's not in dispute, so the question is, was it reasonable failure?
Yes.
Would he have gone wrong in your submission, and if so, why?
He wouldn't have gone wrong logically if he'd set himself that test. But our point is that that was a test that was bound to end in failure because he didn't have the material. He shouldn't have set himself that test. And
why? What's wrong with that when it's your client's own case? What's wrong with considering the case that's put forward by your client in her witness statement?
Well, because my client was putting forward that case for a different reason. She was putting it forward on the basis of an evidential argument that she'd had no maintenance since she left the matrimonial home. This case is put on the basis that that test had to be satisfied to get jurisdiction under Section 27 in the first place. And what I'm pointing out or highlighting is that the judge, having set himself what is effectively an artificial test that you don't find anywhere in the statute, has tripped himself up, trying to achieve too much, or it doesn't matter how one expresses it, but he couldn't do what he set out to do, and he's got a statutory duty under 27.3 to consider all the facts and circumstances. If he thought the facts and circumstances, including life in 2013, he failed to do that.
You had not sought disclosure in respect of 2013 or 14, or just 2013?
Lord, I think it must be 14, because, and that's another difficulty with this test, the Forms E1 have automatic disclosure provisions relating to the previous 12 months. And so a respondent to an application is obliged to supply documents for the previous 12 months.
Yes.
And so to go back 2 years is not something that would have been supplied by the automatic disclosure provisions. And you would have had to have had a special disclosure application, which, as your Lordship knows, may well not have been granted on the grounds that it was going too far.
Hold on. The husband's first Form E is the 24th of April 2015.
Yes.
So that would have gone back to the 24th of April 2014.
Yes.
You didn't suggest that any disclosure prior to that date was required.
No.
And the husband didn't suggest, or his advisors didn't suggest, that any disclosure was required prior to that date in order for Section 27 to become or to be properly assessed. So
Lord,
there was
no.
neither party suggested prior disclosure was required.
Lord, neither party suggested prior disclosure was required until the day of the hearing in front of Mostyn J.
And that's too late.
Well, absolutely, but it
Because
wasn't
you
part
couldn't
of
give
our
disclosure.
Case.
I'm just clarifying. That
Yes.
the Form E goes back 12 months,
Yes.
assuming it's properly
Yes.
complied with.
Yes.
But the husband didn't say at any stage, I should be making, because there's an obligation on him to make full and frank disclosure. It's not, he doesn't have to be asked by the court to do it. He never said, sorry, I have to give disclosure for 2013 or prior to April 14 in order for the court to determine what we're referring to for shorthand inaccurately as a condition precedent.
No, of course he didn't, and of course he wouldn't have done, because why would he have given voluntary disclosure of something that, on the face of the papers, he wasn't expected to give, and wasn't asked by those instructed by the wife to give? But the difficulty is that the learned judge has given himself a gloss on the statute type task to fulfil, which, as it turns out, looking at it in retrospect, is pretty incapable of being fulfilled anyway, because he didn't have that information. But it just highlights how arbitrary the 2-year test that the judge imposed was.
Yes, but my Lord has just pointed out to you that part of the reason he didn't have the information was because your side didn't apply for disclosure in respect to 2013.
No, quite. But Lord, my side would never have applied for disclosure, because my side didn't think that it was necessary to go back to 2013.
Well, but that's clearly not the case on the face of your client's own statement. She makes a complaint of no maintenance going back to August 2012. So why is not the period back to 2012 relevant on the face of her own statement?
Because, my Lord, she can make a complaint about a failure to maintain without asking the husband to include his level of disclosure back to that date. If the husband wants to disclose back to 2012 to show that the allegation made by the wife is not fair, he can do that and say, look, I have done, look at this. I mean, he didn't. Inherently, in this case, he wouldn't have done, because he wasn't asked to and didn't give disclosure of the 2014 et sec period anyway. But in terms of the way the section's been applied by the judge, it just highlights its artificiality and the fact that this is a very odd way to go about it.
Well,
because you only sorry, my Lord,
the obligation is not on you to ask for information. The obligation is on the husband to provide all relevant information.
Yes.
And he never articulated an argument that he should be giving or was required to give disclosure other than in his Form E.
Yes.
So he disabled the court from assessing his resources prior to April 2014, assuming, as I keep saying, he complied with his obligations in respect of his first Form E?
Lord, yes. And our complaint is not with the husband in that regard.
No, I understand that, but the point you're making is that the court was not in a position properly to determine the test it set itself.
Yes, that's exactly my point.
And I was making the observation that the court was not in a position properly to assess the test it set itself, because neither party clearly considered that was an irrelevant period. Because if either party, well, in particular if the husband had thought it was a relevant period, he would have had an obligation to make financial disclosure in respect of that period. And he didn't, and clearly didn't consider he was under any obligation to do so.
Lord, yes.
Sorry, that's a long-winded way of...
Well, no, you're right, and perhaps I didn't explain it clearly enough, but that's exactly my point. But my point goes to criticism of the judgment and the test applied by the judge. So he put himself into an impossible position by glossing on the statute yet again, and suggesting that in this particular case 2 years was an appropriate time during which the wife would have to show that the husband had failed to maintain. Well, it was never going to happen. She alleged it, but according to her understanding, up until, well, let's say March of 2021, she didn't think she had to show that there'd been a failure to maintain in 2013. That was never her test. It was never anybody's test. It was a test that came from the judge, and it was an arbitrary test, and it shows that to impose a test like that during the course of a substantive hearing is likely or may well end in disaster, because you don't know exactly the facts of this case. Test was set. Test in fact couldn't be met. Completely unfair to criticise the wife for failing to show that she hadn't been properly maintained during a period that she hadn't asked questions about, but during a period that the husband hadn't been given specific disclosure of either. So it goes to show that you can't just, with all due respect to the trial judge, you can't just introduce a test that is as long as the parson's nose or foot. It appears that he decided, for whatever reason, and one's speculating as to why he chose that period, because it's not even August 2012 to December 2012, it's 2013 and 2014. Why did he come up with that figure? Particularly knowing that it was hopeless in terms of being impractical, couldn't fulfill it. And consequently, that means, firstly, in this particular case, the wife is penalised to the point of losing a remedy by not being able to prove the state of affairs during that period. And secondly, what sort of precedent does that set for how these applications are dealt with if, at the trial, the judge can say, I think the period that this wife's got to show failure to maintain is this length of time? She has to guess. I mean, in a big case, is it 2 years? In a small case, is it 2 weeks? Well, what is the situation? And particularly when the default position for these applications is 12 months. So we say that the judge failed.
If he confined himself to a 12-month period, the outcome would have been the same, wouldn't it?
Possibly, yes. Yes. But it does mean, with respect, that the judge has failed to consider all the circumstances which he is enjoined to do in deciding the basic question that your Lordship asked me about this morning, that goes back to the date of the application. The interpretation of 27.3 on the, as it were, retrospectively to the date of the application is clearly somewhat troublesome, as your Lordship's questions make clear. But what are we to make with the conflicting provision that all the Section 25 factors have got to be taken into account when deciding whether there is a failure to make reasonable provision. And doesn't all of that militate, as we would say, towards the decision that has to be made as to reasonable failure, a failure to provide reasonable maintenance, to be made by the trial judge in the here and now, and that the applicant is not disentitled from her application by the fact that she may not be able to prove that at a particular time prior to the application there wasn't reasonable maintenance being paid. As I say, the alternative is that she simply updates her application on a regular basis and catches it that way, but that's surely unsatisfactory jurisprudence. It's surely an unsatisfactory interpretation of the section going forward.
Or she could amend the existing application.
Yes, she could.
So you would put in an amendment saying, I'm now relying upon the following period.
Yes, well, what she could.
I mean, that's what strikes me as so unsatisfactory about this whole jurisdiction as it seems to be operating in practice, is that nobody knows what they're shooting at, because you have no statements of case setting out what each party's case is. One's left to guess from the evidence, and it would be good, it seems to me, at minimum, if it were to be required that people specify what period one's talking about. I mean, in the present case, it seems to me that, in fact, your client complied with that requirement because her evidence was actually pretty clear as to what period she was talking about. But leaving that aside, if you want to rely upon a later period, what's the problem of amending your application to say, I now wish to rely upon 2019 to 20?
Yes. I mean, the answer to that is that she wasn't relying on that. She was relying on that as evidence that had been a willful or a reasonable a failure to maintain. But she wasn't shooting for a prior failure to maintain period up until the date of the application. Specifically, she didn't have a date in mind. It was an ongoing situation as far as she was concerned. It had, in fact, on the facts of this case, been going on from her perspective since 2012. But since she had no disclosure at any stage, and since she was chasing the trustees with increasing frustration, but believing at the date of the application that there was a trust fund there that was two trust funds, we've seen that they're currently worth 1.2 or 1.3 million, something of that kind. They were a little bit more valuable back in the day. She knew those existed. She was asking for maintenance on the basis that those trust funds had not been brought into play to provide her with some maintenance. But until she gets disclosure, she can't give chapter and verse. And until she knows when the relevant period that your lordship is concerned about begins, she can't know whether or not there's been a specific non-disclosure or specific failure to maintain, because she doesn't know what's going on inside the trustees' boardrooms. She just knows that she's not getting any maintenance, and she knows it's argued on her behalf that that's unreasonable, that the husband is in a position to pay some maintenance, but if he's not engaging in the process, it makes her job absolutely impossible. And her woes are compounded by the artificial, or the period chosen by the judge to measure his condition precedent test, which merely exposes the inherent unsatisfactory nature of this condition precedent test and the impossibility that the judge has got of complying with his own test, and the fact that it's, we would suggest, a bad test, bad law. And it means that he's put himself in a position where he's not complying with his duty under section 27.3. So all of that we say is not a very unsatisfactory way of this provision working in practice. And your lordship is, as it were, not wrong about, as it were, putting in statements of case, but they did do that, and both parties set out their position in their position statements prior to the trial. And indeed, both parties have been trying to go through the process of disclosure and interlocutory advancement during the course of that process. There's supposed to be a process whereby there's either some kind of mediation or some kind of financial dispute resolution or something of that kind. And the facts of this case, none of that happened at all. Because this case was one of those completely intransigent cases where the husband said, I'm not paying you anything, so get used to it. She said, well, nothing is not good enough. So what was she shooting at? You don't know until you've got disclosure. And I don't want to repeat myself from this morning, but that's the whole point about disclosure. So you do know what you're shooting at. And you can produce a statement of case that makes sense to the other side and to the judge. But this wife was waving a pencil in a vacuum. She knows what she'd like. She knows what standard of living the parties lived to before. She knows what's in the trusts, or was in the trusts, because your lordships may have noticed, but if not, may I draw your attention to it in passing, the letter that the husband wrote to the wife's brother. I don't know if you've come across it in the bundle. It's at the very end of the bundle B, the supplemental bundle. But it's a letter that he wrote back in 2010 to the brother William, when he is borrowing £100,000 from brother William, and he sets out in that letter, but perhaps we should look at it if there's any...
Well, isn't it referred to in the judgment?
Yes.
Is it when the husband sets out his understanding
Yes.
of what
Yes.
His future expectations are?
Yes. Lord, absolutely it is.
And it's, so I think we already have that.
Well, very well. The letter itself is the very last page in the supplementary bundle. But and the point to be made is that this is what both parties thought their financial position was, as of, according to this, 20th of December 2010. I mean, it is worth looking at for a second.
So it's the last.
It's page 496, C496 of the supplemental bundle. Lordship have it. It's a letter to dear William.
Yes.
Very decent to offer to help out in this interim period. It enclosed supplies some background information. We'll pay you back before 2 years are out, pay interest at 5%. Again, this is a very brotherly gesture, which we won't forget, ... And over 2 pages, there's a note written by the husband that was acknowledged in evidence. Information for William Goodall, background, and here is set out the husband's understanding of his trust interests following the death of Lady Mary in November 2009.
And the judge sets out verbatim what we have at 499.
Yes. Yes. And the direct relevance to Charles is the last page. And it looks as though, according to this, he thinks he's entitled to something like...
The judge's finding at 4067 was that those predictions proved to be optimistic.
Yes, correct. That's right. That's right. Optimistic, but not very. I mean, there's what the husband believed is that he was he knows he's a discretionary beneficiary of the Mount Stewart Fund, and he also refers to the.
Can you enlighten me as to where this takes you? Because the judge has quoted the entirety of the salient passage.
Yes.
Found that, in fact, it was optimistic. So how does this assist you?
Lord, it goes to the point that we were on before about the ability that the wife has got to know what it is that she's asking
But she
for.
plainly did get disclosure of this document, otherwise it wouldn't be in the bundle.
Oh, she got disclosure of this document, yes. But this document surely fuels a claim that there's been a failure to maintain when this document in William's hand shows a potentially accrual to him of 3.3 million on the maths. I mean, it turned out that he didn't get as much as he thought he would, and it turns out now that his current entitlement is something like 1.3 million. But nevertheless, that was the basis on which the parties were dealing and operating at the time. So there was a wife at final hearing, not knowing what the test was going to be because the test hadn't been set. The test wasn't set until the judgment. We had no idea that there was going to be a 2-year period. You say it's not in any.
Did the judge give you the opportunity of amending your application so as to rely on future information?
No.
The first day of the hearing? Because effectively he struck it out on the basis of his own test.
Yes.
So it would be, at the very least, you ought to have had the opportunity to amend if his point was right. Did he give you that opportunity?
No, he didn't, Lord. He didn't. In the flurry of activity or excitement, when he said what he said, and invited us to make submissions on the basis of the document that you've seen in the bundle already, his scenarios under the old law. As I recall, because the condition precedent isn't so much in that document as something that was orally given to us on the first day.
Yeah, you said.
And we had to consider on the first day where it took us. It came as a surprise, perhaps it shouldn't have done. It came as a surprise, but he certainly didn't formally
It hasn't
say.
been in either of the opening, yours or your opponent's opening statement. So
No.
it was a surprise.
Oh yes, it was undoubtedly a surprise. Well, to us anyway. And we certainly didn't get the opportunity, or the expressed opportunity, to amend our pleading to say and thereafter or any of that kind. No, certainly not, because that was one of the things we were complaining about, and submissions were made about it. No criticism at all, but my learned friend adopted it in his second written submission, as one can understand he would have done. We didn't adopt it. We didn't produce a second submission because we've done the first one. But we said this is not right, or we didn't agree with it. But also that the conditions of exceptionality had been proved. If he said it was a question of exceptionality to justify the order, we said in the circumstances of this very unusual case, we'd already got that. And then
The other, you've taken us back to section 27, and on page 38 of the bundle, it deals or summarises the procedure to be followed. If you're only seeking an order for periodical payments, you follow the fast-track procedure in Part 9, Chapter 5. Otherwise, it's the standard procedure which applies to all financial remedy applications, which is Part 9, Chapter 4. And that sets out, Chapter 4, the procedure which is adopted in an application under Section 27, which includes an application for a lump sum. And that requires financial statements to be provided by the parties, and the financial statement, the pro forma Form E, sets the parameters of the information that has to be disclosed.
Mm-hmm.
And there's no distinction made for a Section 27 application. So it doesn't say, which it could do, you must provide 24 months of bank statements. You must provide 24 months of pay slips, or whatever it might be. It's the standard 12 months.
yes, precisely. Well, there's no, as far as I know, there's nothing in any prescribed forms that require a disclosure of 24 months, and one knows that applications for disclosure of 24 months are usually met with hostility.
But so the rules set out what information has to be supplied. So if you go back to subparagraph 3A and B, it's the same information for A and B. In other words, it's the same information, all the circumstances of the case, whether the respondent has failed and what order to make. So the judge's approach of 2 years would seem automatically to come up against the procedure as set out in the family procedure rules.
Yes, well, I agree. And if we had no opportunity, or we weren't invited to amend our pleadings following his intervention on day one, we certainly had no indication that 2 years was going to be the period that he picked.
With great respect, that would have been hopeless because you had no evidence.
Oh,
Nobody. I mean, so what are you going to, going back to 2013? If that's one thing, but okay, yes.
I mean, it's probably right to say that the complaints were of a type. The complaints were a fairly continuing complaint of no maintenance, trusts available, no disclosure, and hostile behaviour. And those complaints, it's right to say, would have covered 2013 and 2014. But in terms of whether this court should uphold the decision of Mr. Justice Mostyn, we say that these are telling points as to why this is not the right approach to a Section 27 application. Well, on that point, may I invite you to just to consider for a second the judgment in McFarlane and Parlour.
Yes, we've been forecasting that we would go there for a while, so let's go there. It's tab 3.
It's tab 3.
Yes.
Page 103 is where I'm happy to start.
Sorry.
Paragraph 90.
Thank you.
Inasmuch as Mr. Justice Mostyn has given us a very erudite history of the development of Section 27, and I'm bound to say very much more extensive than anything that either Mr. Orton or myself submitted. So we were on a learning curve or a consolidation curve during the course of his judgment, brackets for which he makes no apologies, I note, in the course of the narrative. But by the same token, Lord Justice Thorpe deals with the evolution of the statutory power and the definition of periodical payments. And he starts at paragraph 87, and he goes back to 1859 and 1866, and the wife's maintenance, necessity, needs, aliment, and then the matrimonial fault, which was there and continued, as we've seen, until 1973, at least. 90, the Matrimonial the 70 Act was a major reforming statute heralded by the Law Commission report on financial provision matrimonial proceedings. That's Lawcom number 25. I don't know if your Lordships have had a chance to read the 2 Lawcom extracts that we've included in the bundle, but we have. They're in this section, and they're the Lawcom recommendations for the reform of the statutes. And 25 was the 1966 one, I think.
No,
69, sorry, 69. Which led to the 1970 Act, described by Lord Justice Thorpe as a major reforming statute. So, but anyway, we've included the recommendations of the Law Commission.
I think if you want us to make any submissions about them, you need to take us to them.
Yes, well, very well. It's what Lord Justice Thorpe says in his analysis of how Section 27 is to work in the future, as well as where it came from. So 3, paragraph 90, subparagraph 3, whilst the primary objective of financial provision orders was to provide income for the maintenance of the spouses, the introduction of the lump sum order had blurred the line between provision from income and provision by way of adjustment of capital. See paragraph 49 of the report. 94, as flagged by us, the term maintenance survives only in sections 22 and 27. In those contexts, the term might have been thought to have traditional meaning. However, the judges have rejected that approach. The argument that the court's power under section 22 to order maintenance pending suit was confined to sums necessary for the recipient's daily support, considered by Charles J and G&G. Lord, there are two, so the whole of that page is flagged by us. Would you like me to read it, or would your lordship speak?
Shall we read it quickly to ourselves?
That would be very helpful, thank you.
Yes.
Your lordship will have noticed in that passage under D3, subsequent amendments to section 27 confirm or clarify maintenance not used by Parliament to refer to the old common law duty of a husband to maintain his wife. The report read alone, together with the working paper, supports the conclusion that maintenance was not used by Parliament to refer to the old common law duty of a husband to maintain his wife. And what Lord Justice Thorpe is effectively saying is that this is paragraph 99, court's power to order periodical payments to reflect more than the recipient's mere element, providing all the section 25 criteria, all the circumstances in the case, and overall fairness so require. So he's heralding in the new approach to maintenance, if you like, disposing of the common law duty to maintain, even though, strictly speaking, it was still on the statute book, or indeed still is on the statute book. That has not been formally abolished, but it's a new broom, it's a new approach, and it's one that this court and family courts have been adopted ever since. And this was the defining moment when, with respect to Mr. Justice Mostyn, knowledge of previous authorities and the matrimonial offence and the common law duty to maintain are no longer relevant. There maybe some would describe this as being, some say it's a bit wishy-washy, some people say there should be more law in this, but the clear words of the section and the practice in this division is that an overall, all the circumstances approach is taken and is appropriate, and the purpose being to provide reasonable maintenance to those who need it, without having to go through the strictures that this lady is being asked to go through retrospectively by Mr. Justice Mostyn, and indeed certainly without the shenanigans that were involved in the West case, when the lady who was exonerated entirely from committing adultery was nevertheless not entitled to complain of reasonable failure to maintain because the husband believed that she had done.
But this is, you're referring us to this because, as I understand, you're submitting that Lord Justice Thorpe is endorsing what Mr. Justice Charles said in G&G, and part of what he said was, to summarise perhaps inaptly, that the old common law duty of a husband to maintain his wife is no longer relevant.
Yes. Well, if I wasn't clear, then I'm sorry, but that's...
No, sorry, yeah.
Absolutely,
Yeah, okay.
yes.
Yes.
In part, as I understand it, because that relates to her mere aliment. I'm bound to say never a word I've ever come across. The new broom at paragraph 99 does say by reference to a word that I have to say is not in common usage down our way.
Not down our way anymore, my lord. So,
What is it?
support.
So we could read that for mere support.
I think that's I haven't gone to the dictionary, but that's my understanding of it.
Okay.
Alimentary provision. Yes, the new broom, exactly. And since we're looking at that, Villiers, I don't suppose I need to refer this court to the Supreme Court decision in Villiers. Our point about Villiers was only that the Supreme Court were perfectly comfortable with Mrs. Villiers taking an opportunity, taking an option that was open to her, available to her. So I say the sophistication of the judgment is not one that needs to concern us for lots of different reasons. But
Well, I thought you were referring us to it because of Lord Wilson's, because all members of the court agreed that forum conveniens was not applicable.
yes,
So that the forum conveniens principles were not relevant.
no, not at that time.
Yeah. Not at that time. Yes.
But what the paragraph that we have flagged for you is paragraph 36 of the Supreme Court decision,
36.
page 145.
Yes.
Just the again the intention of legislation, if you like. Schedule 6 intended to be a comprehensive code to govern questions of jurisdiction in relation to maintenance claims across jurisdictional dimension within the United Kingdom, as the maintenance regulations provide such a code in relation to cases with interstate cross-jurisdictional dimension. No basis for reading down and modifying the plain terms of Schedule 6 by reference to fundamental human rights or the principles of legality. See paragraph 31 of Sir John Dyson. No scope whatever for the operation of a forum non-conveniens discretion in the context of a legislative scheme in Schedule 6. And he explains it a little bit more fully on the following page.
Sorry, which?
Well, it's the fifth line down.
Fifth line.
Yeah.
Where was the sentence start?
In my view,
Oh, got it.
promulgation of Section 6 is authorised under each of the limbs 1 to 4 of Section 22b. Purpose and effect of Schedule 6 ensure there's one coherent, certain, predictable set of rules which apply to all maintenance claims with a cross-jurisdictional dimension, whether the crossing of jurisdictions occurs on an interstate basis or an intrastate basis. They have one set of rules which applies in both types of cases, in the obvious sense in a world where people are highly mobile, liable to move between jurisdictions internationally and within the United Kingdom. Enables everybody to know clearly where they stand and what their rights are without having to worry about and provide expensive legal advice regarding possible differences in the position which might apply if the applicable intrastate jurisdictional rules are different from the applicable interstate rules. And he goes on in that vein. At paragraph 40, he concludes that the divorce proceedings as follows are not a related action, which is not something that Lord Wilson agreed with. But here, 41 is point, I guess. Maintenance regulation, Schedule 6, give her the right to choose in which jurisdiction, within those listed in Article 3, she wishes to bring her maintenance claim. She has an unfettered choice in that regard, is entitled to choose to bring her claim in an English court on grounds of its convenience for her or because she believes that the law it will apply is more advantageous for her. And that's confirmed in paragraph 42, just below. Fundamental object of the maintenance regulation to protect the interests of the maintenance creditor as the weaker party, also indicated by the text of the article, it said, read in the light of the legislative history, see paragraph 21 above. So, well, that's what the Supreme Court said in that case, and we say this is all part of a move to provide reasonable and fair maintenance for a weaker party if that party needs to come to court to obtain that maintenance. And that as a direction of travel, this is helpful, and is not helpful to go through what is, as I say, an undoubtedly erudite discussion of the old cases, going back to Bragg and Wood and Kerr. It should give, in our respectful submission, this court an indication of where, of how this section should be interpreted. But may, as it were, contradict or confuse myself and your lordships by asking you, since we're in the bundle, just to go on to our last authority.
Yes.
Because it's there. It's the case of Newmarch. It's 1976, with judgment in 1977, so it was before the amendment of section 27, but it's since 73, obviously.
Sorry, which tab is this?
This is tab 7.
Thank you.
Yes.
In the interests of time, perhaps I needn't deal with the facts, but it was an Australian divorce which came back to this country. Let me just bring up our passage. May I turn you to, please, 268.
That's a long passage that's sidebarred.
My Lord, it is. I'm, again, very happy for your lordships to read it quietly. Or I can pick out the parts that I've highlighted in yellow to give particular emphasis.
Do you want to do the latter?
Lord, yes. Lord, this is the proceedings for maintenance, subject to the provisional order. The judge had upheld the decree.
The enforceable recognition of the Australian divorce.
Yes.
Yes.
But as far as maintenance provision was concerned, he was much keener to make provision in this country under Section 27. The first section is between B and C. Any order which this court makes will be made after the parties have been divorced. Are Section 27 proceedings capable of surviving an effective decree of divorce? He then went and just considered a well-known case of Wood. The magistrates upheld, the judge, Court of Appeal, in fact, recognized the American decree, which validly dissolved the marriage, but nevertheless upheld the magistrate's order made subsequently. At paragraph F, and this goes to the point, the discussion that I had with Lord Justice Arnold this morning. Lord Evershed is quoted as saying, it's immaterial whether the cessor of the marriage had been brought about by an English or a foreign decree. At G, nevertheless, the Court of Appeal made it clear in exercising the discretion, the magistrates must take into account all the circumstances in which the decree of divorce was obtained in the foreign court, and in particular whether in granting the decree of divorce, the foreign court had or had not adjudicated upon the issue of maintenance for the wife, which, of course, in this case is not irrelevant. Number of different cases to distinguish Wood. The ground was willful neglect to maintain. I accept the views expressed by Purchase in Gray and Gray, which was the pre-runner, if you like, to the 1978 change of law. Section 27 jurisdiction of the High Court is plainly an extension of the powers granted to justice under the 1895 and 1960 jurisdiction. I therefore consider the principle in the Wood case as applicable to Section 27 orders. He then talks about the power to vary. It's also, and then Section C, it's also clear from Section 28.2 of the Act of 1973 that an order for maintenance may survive a decree of divorce, but ends with remarriage of the applicant. He then sets out 28.2, which we looked at this morning. If you then go down to just below E, and being asked to make an order for maintenance under Section 27 in favour of a wife who ceased to have that status as long ago as October 1975, this point does not affect the jurisdiction to vary or revoke or confirm the interim order made on July 16, 1974. Hodson L.J. summarises the argument for and against the view that the power to make orders under the comparable jurisdiction of justices survives divorce in this passage in Wood, and he then deals with the passage in Wood. Bottom of the page, in Bragg, 1925, an opposite conclusion was reached. It was held the decree does not ipso facto discharge a maintenance order obtained under the Act of 1895, nor does such a dissolution compel the court to discharge such an order. And then this, in every such case, it was held comes within the discretion given to the court by Section 7 of the Act to vary or discharge the order on evidence of fresh facts. Mostyn J pointed out there were no words in the Act to show the order itself is to be limited to the period of the marriage. Sir Henry Duke thought that there were grounds of common sense why an order that dealt with maintenance and not with general obligations of married life should continue to subsist. Bragg was decided in 1924 and has been followed consistently. And then you can see at the very bottom of our blue flag, I think on balance supports to be found in his observations for the view that a discretion remains to make an order for maintenance under Section 27 of the Matrimonial Causes Act 1973 and the proceedings started before the divorce of the parties, even though before the order is made, the parties were divorced by a decree in a foreign jurisdiction. And then the last paragraph, including the two aspects, in my judgment, upon the whole facts of this case, including the two aspects mentioned, such a finding is open to this court.
Sorry, wait a minute, where are you?
Sorry, my Lord. G, 270G.
270G. In my judgment, yes, got it.
Question of when the order can be made.
Yes.
Every relevant circumstance must be taken into account in reaching a decision. My findings show this wife's entitled to an entire need of financial support from her husband, who at all material times had the appropriate means for providing it. He's well aware that the court which granted the decree of divorce did not deal with the wife's financial provision. He's made no periodical payments. Having regard to all the circumstances, I'm satisfied the justice of the case requires I should exercise my power to make an order under Section 27. My Lord, that is that's relatively old, but on point in respect of a number of the points that we've made in our skeleton. And my Lord, that deals with the authorities that we're referring to this court. You'll see in our skeleton, of course, we refer to a number of other ones, which I imagine will be familiar to the court. But we say that those authorities, considered together, show that the four grounds of our appeal are well made. I was just finishing the question of how long the condition precedent period should be. I may have made all my points, but it is a major insurmountable problem as to how you deal with disclosure and your statement of case if the length of period of that disclosure is unknown. And what we say is that it's curious, if you like, but the judge has, to a certain extent, made a rod for his own back with the finding that the husband could and should have made maintenance payments in 2019 and 2020. And to take up the point made a few minutes ago, if the judge had thought or had in mind that he was going to find on the evidence that he had in front of him, particularly the accountant's letter, that there could have been maintenance payable, not only that, there should have been maintenance payable, for them to say, actually, bad luck, you didn't hit the threshold test. So even though I've now heard the evidence, I make a finding that you would otherwise have been entitled to this amount of money, albeit small, by way of maintenance. And therefore, had you amended your pleading, had I invited you to do so, and had you do so, I would have found that you were entitled to 10,000 a year on an open basis, bearing in mind the disclosure that's been given. What a curious and unfortunate way to treat an applicant with respect, who doesn't know that this is coming, has no idea that she's going to be at the end of some, we say, slightly controversial jurisdiction arguments adopted by the judge, and find that actually she would have won had she known that she had to amend her pleading on day one. This is surely not a way to conduct a maintenance application. Lord, I see it's 3 o'clock.
You're going to take us to the Law Commission just briefly to show us what you wanted to draw
yes.
from that.
Yes,
Because
of course.
as we got this bundle.
Yes, my lord, please, yes. Certainly. So the first...
Have we got more than one? We have one extract, is that right?
There are two,
Other?
but they're very short.
Oh, I see, we've got another one. Yes.
The first one is 1969, and it's at page 51 in the bundle of authorities.
Oh, okay. Is it just one page?
Yes. Well, we've only given you the extract. We can provide you with the whole report
No,
if you would like. It makes for interesting reading. If you were in any way lacking in
Get
such.
it online. Yes.
But it is online, exactly.
And
So-
that may turn on your definition of interesting.
Well,
But this is the Law Commission report from 1969,
yes.
and it, just stylistically, it's quite interesting because, possibly unlike now, the Law Commission says in terms what the amendment should be.
Well, they do, and they also draft. I think they also draft the new act. They're very they're very prescriptive.
Yeah.
So this,
So which bit are you showing us?
I'm showing you mostly the first half of that page, abolishing the difference in nomenclature between maintenance alimony, not quite aliment, but close to, and periodical or lump sum payments, which should be abolished. All should be described as financial provision, except alimony pending suit, that's otherwise known as maintenance pending suit, and that's what they recommend. No distinction between the powers of the court in relation to husbands and wives, which was a dramatic change at the time. All forms of periodical financial provision, but not maintenance pending suit, should be capable of being secured. D, all periodical financial provision should cease on the remarriage of the payee and not be capable of being revived. The court, and that's followed through, obviously, as we saw, to 28.2, that on the remarriage of the recipient, her claim under Section 27 goes. E, the court should be empowered to award a lump sum not only in respect of the future, but also to enable the payee to discharge liabilities reasonably incurred prior to the institution of the suit in order to maintain the payee, or the children, and order any lump sum to be paid by instalments. So extending the powers there. Greater use should be made of the powers to award lump sums and secured provision. Lords, if you then go down to the next page, you've got the 77, Law Com 77, which is, I think, 1976, and led to the 1978 amendment to Section 27. And this is an interesting, well, subject to my definition, of course, an interesting history, if you like, of Section 27, and the Law Commission set it out there.
Sorry, which page are you on?
Lord, I'm on page 52.
You might be. I'm not. Mine aren't. Can you tell me the internal page of the extract?
113.
It's 52.
Is it?
113 and 114.
Well,
Wait a minute, this
the
is the Law
document
Commission
itself is 113, yes, the Law Commission document.
Is it number 77?
It's tab E.
Oh, sorry. Yes, I was looking at a completely wrong document.
Tab E, thank
What's
you very
this
much.
from?
This is from the Law Commission report of 1976.
Thank you. Number, do you know? Number 25. No. the other
77.
one. Number 77. Thank
77. And this is a substantive one, my lord, because this is effectively where the whole concept of willful neglect, the willful neglect element went. And this is the provision that brought in failure to provide reasonable maintenance,
you. Right.
which is where we are at the moment.
Yes.
So it's an important variation. This. Well, you see what the various proposals are. Formulating the guidelines, proposed that the maintenance order should cease to have effect if the parties cohabit, housekeeping orders, and so forth. We've considered all of these and indicate whether we think a corresponding amendment ought to be made. Before doing so, we think it may be appropriate to refer to the history of the section in order that what we have to propose may be set in its appropriate context. And then, well, again, I can read this or I can leave your lordships to read it. But the history section is 2 pages. And it shows the development of the thought process through the legislature. Make the point at the beginning that ancillary relief is a slight misnomer. It wasn't in fact ancillary to anything, but independent proceeding entitling the wife to obtain financial provision without asking for any other form of relief. That was the 1965 Act. We further noticed surprisingly little use had been made of Section 22. That's the yes. So that if it had remained in the current form, it seemed likely that even less use would be made of it. We consider whether the section ought to be repealed altogether, and then this is what's important. We conclude, however, this would not be a satisfactory solution. Secured provision can't be awarded in a magistrate's order. Secured provision has great advantages from the point of view of the payee, since it's unlikely to give rise to any problems of enforcement. And then this, 9.6. In the light of these considerations, we decided to propose the retention of the provision contained in section 22. So they thought about junking the whole thing because it wasn't used very much. And they say, no, it's a good act, it's a good section, and it should be used, and it should be bolstered up, fortified. And then maintenance pending suit came in at that stage. Gender equality, if you like, under B, that the wife can be ordered to maintain a husband. There was no power under the section to award a lump sum. We recommended there should be, and any secured provision awarded under the section should be capable of lasting for the life of the payee. Again, all part of the general move. Our recommendations for reform was given effect by Section 6 of the 1970 Act, which has now been replaced by Section 27. And then further considerations of Section 27. Against this background, we now consider whether specific proposals mentioned in paragraph 9.3 above should be carried over into Section 27. And they then proposed that magistrates should take into account income, earning capacity, property, other financial resources, financial needs, obligations, responsibilities of each of the parties. And that was at Section 25. We considered it wouldn't be sufficiently comprehensive. The right course is to reproduce as far as possible the guidelines contained in Section 25 of the 73 Act, modifying them only so far as is necessary to reflect the rather different circumstances of the parties bringing their marital difficulties to the magistrate's courts. And so, and they don't 9.10, they don't recommend, or they didn't recommend statutory guidelines for Section 22. And Lordship knows, Section 22 has flourished and developed with assistance from Mr. Justice Charles, Lord Justice Thorpe and other judges who've expanded, Justice Holman, who've expanded the jurisdiction effectively to provide maintenance for, in the unmarried case, for a wife who is in need of maintenance.
Yes.
So, Lord, those were our authorities. You have our submissions as to on the three grounds. If I'm leaving any further reference to failure to draw inferences.
You've made that submission by reference to 102 and 103.
My Lord, yes. Name Lord, thank you. I quite agree, and I probably said too much about it this morning, but that is certainly dealt with. So I was on the question of the order and what the threshold period should be. And our submission, as you will have gathered by now, is that when the case comes on for hearing, the judge is being asked to make a here and now order for maintenance to the wife. He should ask himself the question, has there been a failure to maintain in this case before the date of the application or thereafter? If so, can make a here and now order, quantum subject to the normal discretion. There doesn't have to be a continuous failure. Intermittent failure is well within the test. And so we say, with great respect to this Justice Mostyn, that to pigeonhole this into the pre-application straitjacket that he has done is contrary to all the indications that we've got from all of the courts between 1978 and today. And although I completely understand the force of the point that the Lord Justice Arnold makes, nevertheless, the mere fact that the judge is bound to ask a question which he's bound to ask and which will almost certainly always be answered in the affirmative. In other words, possibly, has there been a failure to maintain? Well, yes, because that's why the application is brought. So in the ordinary course of events, that is what will have triggered the application itself. But for this court to construe that, and that checklist, if you like, or that as condition precedent, as Justice Mostyn called it, into a principle of law, is really quite abusive of the intention and the purpose of this section. And as in this case, has created great difficulties. It's illogical, it's artificial, and it's not fair. And it shouldn't be allowed to stand, and this court is respectfully invited to give guidance as to the right way that these applications should be dealt with in future, which will not include a condition precedent of that type. It will also not include a reference to a specific period prior to which a failure to maintain has to be proved by the applicant. And so far as the duration is concerned, well, this our skeleton, page 34, paragraph 43. This might be my last word.
I'm sorry, Mr. Gavid, could you make that reference again?
Lord, yes, it's page 35 of the first bundle.
Yeah. Paragraph 43. Yeah.
Paragraph 43. Our complaint is that he misdirected himself as to the potential duration of orders made under section 27, holding that it would be amount to an exorbitant extraterritorial exercise of jurisdiction to allow a maintenance order to have effect after a foreign divorce, save in exceptional circumstances. We say that is a gloss on the statute. We say that the statute says nothing about that. It makes no reference to exceptional circumstances, And as we've seen this morning, Section 28(2) doesn't restrict orders continuing after divorce, providing that the wife doesn't marry. In fact, not only that, it actively acknowledges the possibility that that might happen. And it's leaving the power to provide fairly for an applicant who almost certainly will be resident in this country, well, in fact, to establish jurisdiction, she or he has to be, to obtain relief in appropriate circumstances. It's not an attack on an exorbitant extraterritorial exercise of jurisdiction. It's to provide maintenance in this jurisdiction following a foreign divorce, where it's plain that remedy is needed.
I think, as you said this morning, it's not necessarily limited to a foreign divorce.
No.
And if the limit is provided by 28(2), then it's not limited to a foreign divorce.
Lord, yes, absolutely.
So the extraterritorial exercise of discretion is wrong on your submission.
It is. It absolutely is.
I mean, you're either right or wrong, but whether you're right or wrong, you say it applies to either domestic, well, it applies to both domestic and foreign divorce.
Yeah, my Lord, I do. And Parliament has expressly, after a lot of input from the Law Commission, has expressly drafted 28(2) in those terms. And I ask rhetorically, what else could it mean? I accept the argument that just because the court's got the power to extend the order beyond a foreign divorce, it doesn't mean it has to. But that's axiomatic within my submission anyway. The court has got the power to, as it were, do justice. And if it thinks it's appropriate to extend it beyond the foreign divorce, then it can and should. And to introduce this gloss is unprincipled with respect. So you see what we say, paragraph 23, might have followed inappropriately, blight the exercise of discretion to be afforded on any remittal of this case to the court below, in the event of the success of this appeal, or otherwise influence courts if the applicant were to make a fresh application based on the proven 2020 failure to maintain, for example, or other cases in the proper exercise of discretion under section 27. And then we say further and more generally, these comments demonstrate a continuation of the learned judge's pessimistic view of the previous decisions on this case by the Court of Appeal, who found against him, and the Supreme Court, who found against him, and that there exists jurisdiction under section 27 to make orders for maintenance. We challenge paragraph 44, forum convenience, no role to play in the jurisdiction. The judge has impermissibly introduced an exceptional circumstance test to the exercise of discretion. The clear intention of Parliament was not to apply any limit, either by limitation or statutory consideration. Lord, I've read you our reference to the Supreme Court. Lord Wilson expressed his views about that. There's a discussion about convenience. Just be repeating it if I read it out to you. Bragg was an interesting case, but it's 1925. And in the case of Kirk, the English judge decided that all indications in the case suggested that he ought to send it back to Scotland on the facts. And again, one can't object to that as a matter of law, matter of principle, but he has that discretion. Whereas in yes. So statutory gloss, Law Commission report. I've shown you the respective sections, the development of the law from neglect to maintain, guilty of willful neglect, morphing into willful neglect, morphing into providing reasonable maintenance. We do say if the judge is right about that, if our submission is wrong, the judge was wrong not to find exceptional circumstances in the present case justified the making of an order. and we set out at paragraph 63 of our skeleton the reasons that we say an exceptionality finding is justified. It's hard to imagine, with respect, a harder case for a wife than this. I'm sure one possibly can, but if one incorporates all the elements of the factual matrix into this and see what his approach has been, in other words, he's not going to pay her anything, and it's made it perfectly clear as a matter of principle, irrespective of any income received by him, continuing and deliberate breach of the interim maintenance orders, behaviour in Scotland allowing the matrimonial home to fall into rack and ruin, and turning it into negative equity, which may give her the potential to be sued on the mortgage by Barclays Bank. We don't know that. Materially different law relating to the award of maintenance payments between England and Scotland. The advice she's got about inherited assets. And then, Lord, we set out a whole series of factors, the husband's trust interests. Very odd that a husband who is the sole beneficiary of one of the funds, and it's got his name on it, says that firstly, he hasn't asked the trustees whether or not they'll give it to him. He says, well, you know they won't, so there's no point in asking, but that's no answer to a specific question that might involve them having to exercise their discretion honestly. And then, in fact, the other beneficiaries have been paid in full. I went through this morning. The trustees of the Lady Mary Berry Trust, bar the professional trustee, are either family or family friends. Failure to provide any meaningful or accurate financial disclosure. Litigious nature, 4 years taken up by his attempts to appeal the order of Parker J. The reasons of the above absent provision under section 27, the likelihood is the applicant will receive neither maintenance nor capital provision following a marriage of 17 years to which she contributed very considerably, both financially or otherwise, and from which she suffered considerable economic loss. So, Lords, we submit with respect that if you get there, we have more than demonstrated that this is an exceptional case that should satisfy the Mostyn test if you uphold it. Lord, may I take instructions?
Do you have any questions? What happened to the costs of the previous Supreme Court?
Lord, subject to any questions your lordships have, those are our submissions.
The only question I have for you, Mr. Clifford, what about the costs of the foray all the way up to the Supreme Court? Were there any orders as to costs?
There was the condition to appeal to the Supreme Court was given subject to a payment of £30,000.
Yeah, so that presumably was paid.
And that was paid.
But any orders as to the costs of the hearings? I mean, in ordinary litigation of this kind, the wife, having been successful at all these stages, would have costs orders in her favour.
Lord, certainly.
I don't need to see the orders. I just wondered what the overall cost position was. Were there, effectively, the question is, were there costs orders currently unpaid?
Yes. 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 There's the references in the judgment to the Parker cost orders, which are outstanding, and we were asking for those cost orders to be part of an order to be paid in any event, and irrespective of any question of failure to maintain. And I don't, at my fingertips have the figure, but I think Justice Mostyn mentioned it in his judgment, and we certainly mentioned them in our skeleton. The Supreme Court made a cost order that was, as it were, based on what they ordered him to pay into court. So there was a cost order in respect to the Supreme Court. As far as the Court of Appeal hearing is concerned, I'm not sure.
I mean, I appreciate that you're all acting pro bono, so that might have been reflected. But in the real world, there would have been costs orders against the loser, which, for all of that litigation, was the husband.
Lord, certainly. And I don't have the orders.
No, don't worry. Well,
but we can do that very quickly. Because there are outstanding cost orders, and we did ask for them to be part of an order, and Mr. Justice Mostyn, I think he said he would have ordered them had he found jurisdiction. And it's right. It's right that Mr. Callum and I were paid for the Mostyn hearing by our lay clients, friends, and supporters.
Yes, I understand that.
And it's only after that we agreed to carry on pro bono.
No other questions. Thank you very much.
Thank you very much, my lords.
Yes, Mr. Horton.
My lords, can I just answer with a bit more specificity the answer to my Lord Justice Coulson's question? Paragraph 88 of the judgment, page 109, there is set out the estimated costs owed by Mr. Villiers as a result of the hearing before Mrs. Justice Parker and this court in May of 2017.
Sorry, which paragraph?
Paragraph 88, page 109. my lord. Sorry.
Thank you.
I think it's right to say that Mrs. Justice Parker has not in fact made a costs order. There was a, just to be strictly speaking accurate about it, there was a judgment that said she was going to do so, then there were further written submissions and no order ever emerged. The Court of Appeal, my lord, in this court, when your lordship, along with Lady Justice King and one other, dismissed the appeal on jurisdiction, made a costs order. There was no payment on account sort of that cost order, and there had been no attempt to enforce it. And there's nothing that my client would have been able to do to stop that. I don't think there's even been any notice of commencement of...
But so the wherever it came from, the outstanding costs were estimated to be 71,000.
Oh, there's been no assessment of the Court of Appeal costs, and there's been no actual costs order of any fixed sum made by Mrs. Justice Parker.
Where did the figure of 71,000 come from then?
My lord, I think that's either from my learned friend's schedule put before Mr. Justice Mossman or mine, but it's based on what the claim for costs would have been in both of those cases.
So there are court orders that establish a substantial liability, but those have not been finally quantified.
My lord, no. And of course, I mean, they're nearly now 4 years old, and there's been no attempt on one of them to have them assessed, and certainly no attempt to enforce them.
Well, that's the negative. I'll put it again. There's a substantial liability in costs unpaid.
My lord, yes.
And I assume no offer made to pay any part of those.
My lord, no. And of course, that's, my client has only had receipt of legal assistance through the Bar Pro Bono scheme and the scheme.
Yeah, no, that I follow. It's just that there are obviously the various failures to comply with court orders, but it was only on those last submissions that I was appreciating that there is effectively a further series of orders with which the husband has not complied.
My lord, yes. I mean, their judgment. I'm going to say in a moment or two, if I may, I'm going to take issue with this notion that my client is in serial breach of a number of orders. But I'm going to just, if I may, just start off, if I may, my lords, by just making sure that the court has got the additional documents that have been provided this week. So on Monday, my junior sent to the Court of Appeal, I think it's finally got to your lordships now, a copy of the decision in West.
Yes, we've got that.
We've also sent up 2 additional extracts which are loose from Law Column 77.
Yes, I put those in the tab. I think it was tab E, I think.
Yes, my lord. Yes. So we've provided a part of section 2 of that report, paragraphs 2.1 to 2.14, and we've also supplied today the whole of section 9 of that report. So in the original bundle of authorities, there was an extract of that, pages 113 to 114 only, and we've gone on either side of that, so the court's got the full section of that report, and I'll be referring to those.
It may be entirely my fault. I haven't got that. I've got the first extract.
I'm in the converse position, so I've got the extra bits of part 9, but I don't have part 2.
My Lord, Lord Justice Moylan will have both, and they'll be annotated.
Ben, I have got both.
I have checked, Ben.
And Sorry, just to check. One is from the Law Commission number 1977.
Well,
Sorry,
they're both from 1977.
they're both from
The
77.
first one
Is
pages. It's paragraph 2.1 to 2.14.
Yes, got that.
And we provided the front sheet of the
Yes,
of the report
and the index, context.
and then we provided pages 5.
And they've got 9.1 to 9.24.
My lord, yes.
Yep,
920,
okay.
I have that now. 924. Is that the last paragraph?
My lord.
Section 9.
In my lord, it is, or certainly the last relevant section of paragraph section 9. And finally, my lords, we have provided the amended or the most recent form, which is practice form D50C, well known to everyone, which is the current application form for making a Section 27 application. And it was amended by the Rules Committee in January 2021 by doing two things. One is the general project of amending all family forms so that originating process includes a statement of truth, because until recently many family forms allowed you to originate actions without even having to verify the contents by statement of truth, but also they include the new jurisdictional requirements post the implementation period, and we'll be referring to those in due course.
I can now reassure you that I've belatedly found the extra bits of the Lawcom report.
Very grateful,
Apologies
my
for
lord.
overlooking it.
My lords, I intend to get going with the meat of my submissions presently, but I just want to take stock of where the appeal is at and what is left for this court to decide. And like my Lord Justice Arnold, I looked to the appellant's notice, which is at page, particular page 11 of the core bundle, to see what it is that the appellant, Mrs. Villiers, was seeking by her appeal. And conspicuously, no new trial, but an order for joint lives, it's clarified to be joint lives maintenance of at least £10,000 a year and an adjourned lump sum. I understand, my own friend, now to be saying that no challenge is in fact made to any of the judge's findings of fact, and that the order they seek is simply an order for £10,000 per annum. And if that's the case, my lord, I won't address the court on why the judge's findings of fact were A, not wrong, or B, correct, if I can put it that way. My lord, I also won't address the court on the non-disclosure point, because in my submission, if it is the case of an appellant who says the judge went wrong because he failed to deal with non-disclosure properly, it is, as night follows day, I submit, inevitable that a new trial will have to be ordered. The trial has miscarried, the judge has got the evidence wrong, he's misdirected himself on the non-disclosure, it's got to be done again. So
I think if you want to challenge the judge's conclusion that your client's failure was, I can't remember precisely the word he used, whether he used egregious or some other word.
I think that was my word.
Because that word is your word.
There are many, many adjectives one could use, my lord, and I'm not going to trade them. I'm not in any way suggesting that the judge's findings were wrong about that.
About the nature or quality of his failures.
My lord, yes.
Yes.
But I don't want the court to get carried away and to say that the court knew nothing about his finances between 2012 and 2015, when, as I will show the court in a moment, there were questionnaires raised and there were questions answered and information given. And those answers stood from 2016 and were never challenged in any period of time between 2016 and 2021. So I say I don't seek to defend what Mr. Villiers did in terms of his non-disclosure. I should just point out that he wasn't saying that he couldn't go to the bank because he might give someone COVID. What he was saying was that the rules about lockdown in Scotland were very strict. It was unlawful to go to a different borough or different local authority area, and that's where his bank was. The judge didn't accept that, but it wasn't, as Mr. McMullen from Caford suggested, that he was concerned about giving someone COVID.
So
Be that as it may.
presumably after the restrictions were lifted, he went to the bank, got his bank statements and disclosed them.
My Lord, no, because the trial had taken place by then. And my Lord...
That's a different point. The answer to my question is no, he didn't.
My Lord, no. Forgive me, where a judge disposes of a trial substantively, I have never seen in either civil or family proceedings any pursuit of interlocutory orders made in the run-up to that trial to give that trial judge evidence.
Well, you'll forgive the expression, but because the dog ate his homework on that occasion, he's all right.
My Lord,
you said you didn't want to defend him. Speaking for myself, I simply think that in this case, his position is indefensible, and I don't think it's a wise area.
My Lord,
we're here to deal with the point of principle about what you take into account in terms of making an application under Section 27.
Forgive me, my Lord. This court's allowed my friend to give this court a version of events. Insofar as that version of events is relevant, I simply want to make sure it's accurate. And that's what I intend to do if I'm allowed to do so, my Lord. So I say, in terms of what this appeal is about, it is only, in my submission, about what's loosely described as macro ground one. Is there the need to show some fact or ground or condition precedent before you get to make an order under Section 27? And if so, what is it? And then it's macro ground three, what is the correct approach to the duration of those orders? My Lords, I can address you on other issues, but as I understand it, those are the only issues that survive. Let me say something quickly, though, about what I say is a non-issue, and that is the idea that this court should substitute an order adjourning the lump sum claim. I accept that it's in the notice of appeal. None of the long grounds, the long list of grounds in the grounds of appeal at pages 18 to 20 anywhere assert that the judge was wrong not to adjourn the lump sum claim. And this is the point we make in our skeleton. He can't have been wrong not to do so because he was never asked to do so. The only hint as to the basis of any such adjournment is in a footnote at page 24 of the core bundle in my learned friend's skeleton. And there are authorities that are referred to there. They are about adjourning not a Section 27 application, but an application for financial orders on the breakdown of a marriage, a full-blown, what we might call Section 25 case. My Lords, I can, if necessary, provide chapter and verse, but it's my submission in relation to a Section 25 application that an adjournment of a lump sum claim is both exceptional and only merited where there is a finding of fact that there's going to be a change in the position in the near future. It's not just Macawberism hoping something will turn up.
Well, Mr. Horton, you've taken us to pages 23 and 24, where it's quite clear that the wife's object of this proposed appeal, as it says, is to procure or obtain an adjourned lump sum order. So I'm a little surprised to hear that you're saying if this is an issue that's going to be addressed, you're going to take us to authorities that aren't, I assume, in the bundle.
My Lord, I say it's not open to my learned friend to seek that because there is no ground of appeal which alleges any error on the part of the judge. And if they were saying that we should have an adjourned lump sum, they are obliged by the rules of this court to say the learned judge was wrong in not adjourning the lump sum claim because X, Y, and Z. And the simple point, my Lord, about that is he's not wrong because he wasn't asked to.
Well, I think you make 2 points. One, the judge wasn't asked, therefore he wasn't wrong. But two, it's not a ground of appeal anyway.
My Lord, yes. And the third one, if it comes to it, and I can address you, is it's got no merit. My Lord, and forgive me, the principles that I set out are the ones which I derive from reading the ones which are in the footnote, the authority set out in that footnote on page 24. My Lord, before I get going
When you say
there,
the principle, you mean that it's exceptional and only if there's an imminent change of circumstance?
my Lord, yes. And on the facts as found, in relation to both sets of will trustees, there is simply no basis for any such adjournment. That's the merits argument. So, my Lords, forgive me if I just deal with a few corrections before we go. The first is the continued suggestion that there was no point taken by either party about the need to show any form of condition precedent before the court could make an order under section 27. And my Lords, it's at page 434 of the supplemental bundle, and it's paragraph 31, subparagraph 1 of my and my learned friend Mr. Lang's opening note for the hearing for Mr. Justice Mostyn.
Sorry, which paragraph again?
31, my Lord, subparagraph 1.
But that's not addressing the judge's point.
My Lord, forgive me, because there are times in my learned friend submissions where he appears to be inviting this court to say there's no need to prove anything. There's no ground or condition precedent at all.
Well, let's stick to the point as I understand it. The point between you is, do you take into account events that happened after the application? The judge said no. You're not saying at 31.1 that you don't take into account events that happened after the application.
My Lord, so...
It's no more straightforward, it's no more complicated than that.
Well, I'm grateful that, my Lord, you think so, because at times there is
suggestions. Lord has said, can we deal with you're submitting this this raises the point articulated by the judge in his judgment. Is that right?
My Lord, I say that.
But can I just get? Is that your submission? No, yes or no?
My Lord, forgive me. I'm not saying there that I say specifically that the failure must exist at the time of application, and I don't wish to say anything. It clearly doesn't say that. What it does say is that there is a need to show that the ground in section 27 is made out.
Well, that's circular and takes us back to what section 27 means and how you interpret it.
My Lord, yes. But as I say, and I will make the submission, and just in case anyone's under any misunderstanding, I say that you do have to show a ground in section 27 before an order is made. Now, whether it's a cause of action, whether it's a condition precedent, I'm perfectly happy to call it whatever anyone's comfortable calling it. I'll use the word in the statute, which is a ground. Unless a ground is made out, the gateway to an order in section 27.6 is not made out, and not there. And so I say that the idea that there had to be a ground is not news to anyone. Now, what that ground was is a different matter, I take it, but there has to be a ground made out. It is not simply whenever a court might think it would be a good idea during the subsistence of a marriage, the court will make one of those orders. There has to be a factual determination made. My Lord, I say that's clear from the wording of the statute, and it's also clear from authority if we need to go.
Yes, could I just pursue my Lord's questions in a slightly different way? As I think you've appreciated, as the argument has developed, it now appears that we are faced with two questions, one of which might be labelled substantive, and the other of which might be labelled procedural. So the substantive question is, as of what date do you have to establish the statutory ground? But then there's a procedural question, which is, was it fair for the point to be taken when it was and in the way it was? And the question I want to ask you is this. Do you accept that it was manifest from the wife's conduct of the proceedings in the run-up to the hearing, down to and including the opening note, that the wife was relying upon financial circumstances arising post the date of application? And secondly, do you also accept that your side never raised any objection to that, saying it's not open to you without either bringing a fresh application or amending your present application?
My Lord, we never suggested that an application should either be amended or a fresh application should be made. Just on that, I say amendments relate back, so they're not going to work. If you want to cure the defect, you have to make a fresh application. And of course, the difficulty with that for Mrs. Villiers is that any fresh application could now be faced with a forum non-convenience argument following the change in the internal jurisdictional rules. My Lord, so the second aspect of your procedural point is this. When the court is being asked to make a Section 27 order, it has to decide two things. It has to decide, was there a failure to maintain at the date of the application or proximate to that? And secondly, what order it should make now. Because there may be circumstances where it's quite obvious that there was a husband or a spouse who had significant spare resources at the time of the application, but no longer has any resources at all. If Mr. Villiers was earning £100,000 a year in 2015, he was made bankrupt in 2016 and hasn't recovered, there will be a finding that there was a failure to maintain, but the court will make no order. So I say that there are two questions that always have to be asked. Was the ground made out? And what do we do about it now? Because of course, this judge made an order that said he should now be paying £10,000 a year. I'm not going to backdate it. I'm not going to make any order for payment of arrears. So that's what the judge said if he was wrong about the time at which the ground had to be made out.
That's your answer to my Lord's second question. What was your answer to his first?
The
first,
is it
do you accept
procedurally
that
fair?
it was manifest in the wife's conduct that she was relying on financial circumstances that post-dated the application?
Well, of course she would do, my Lord, insofar as
Is
she
the
was
answer
asking
yes?
what order to make now.
Is the answer yes?
My Lord, yes. I mean, my Lord, it's not like a situation where there's a split trial of liability and quantum. One would have to take all the factors into account in deciding, A, was there a failure to maintain as at the date of application, and B, what do we do about it now?
Mr. Horton, what we're asking you directly is the point raised by the judge was a new point, not raised by any party prior to the hearing, not foreshadowed by any party prior to the hearing.
My Lord, in terms of when the failure to maintain, I agree it's a new point.
It's a new point raised by the judge of his own volition, not raised by any party previously, not foreshadowed by any party
My Lord,
previously.
yes. No application was made to adjourn, either on the basis of non-compliance with orders for disclosure or on any other basis. No application was made to amend. No application was made for permission to put in a fresh application. And the point was raised fairly and squarely on day one, and submissions didn't finish until 3:30 on Thursday.
So you say the response to this new point should have been an application to adjourn to enable disclosure, amended application or fresh application to be made, new disclosure, and then what?
My Lord,
Then an argument about forum convenience on the new application?
my Lord,
Is that your submission?
it's not for me to advise learned friend as to what to.
Yeah, but what are you saying should have happened? You were saying no application for adjournment, suggesting that an application for adjournment might have been an appropriate response. Are you submitting that or not?
I suppose it's like any litigant who comes to trial and finds that there's a point against them on the face of their pleadings. They have a choice to make. Either they apply to amend very late and suffer the consequences of that, or they carry on with the pleadings that they've got. And that's what the applicant in this case did.
And this is all in pursuit of the overriding objective.
Well, my Lord, yes, because people have...
It is.
My Lord, yes,
That's your
it is,
submission,
yes.
right? Thank you.
And as far as what the judge said, I think this is right, isn't it? The judge referred to his so-called condition precedent, but he didn't refer on the first day of the trial to the 2 years.
My Lord, no. I'm going to come on to that point in a moment, if I may. But I just wanted to make a correction. Insofar, because the condition precedent is meaning two things, I want to be absolutely clear that, as I say, there was pointed out at the beginning of this trial that there needed to be a ground made out before an order could be made. I don't say that it was the ground that the judge found was the ground that needed to be made, but there was pointed out there had to be a ground. And it's wrong for my learned friend to say otherwise. Well, the second point of correction or clarification is simply now that there is no challenge to the judge's findings about, in particular, the maternal grandmother, Lady Mary Berry's trusts, I just asked the court to remind themselves of the findings that the judge made at paragraph 126 about those. He answers what he called the Sharman question in a great deal of care. And I say that in those circumstances, all the swathes of documentary evidence that we have from the trustees, including years' worth of correspondence, does seem rather unnecessary in those circumstances. My lady friend refers more than once to the fact that my client's entitled to monies from the trust, which is, I say, a rather unfortunate way of describing his status as a discretionary beneficiary.
I thought he was entitled to the income from at least one of the trusts.
Although the word entitled to 1.3 million has been mentioned this morning, and again, I'm sure your lordship has the point, but he's not entitled to that capital. And in particular, page 123 of the core bundle and subparagraph 10 is where the judge deals with all of the points about, well, why didn't he make a request? Surely it's his money. The other beneficiaries of his generation have had theirs, so why hasn't he had this? One of the difficulties, my lord, is this, is that the complaint is made that this trust, the grandchildren's trust, is not breaking even. And one of the difficulties is that the trustees continually have to write letters to the solicitors for Mrs. Villiers, making the same point over and over again and producing reams and reams of disclosure. And one would hope if that exercise is no longer being done, that the fund might actually stop going down in value. My lords, I want to correct, if I may, the suggestion that there was simply no information before the court about Mr. Villiers' financial circumstances between the date of separation and the date of the application. Now, my lords, in efforts both at trial and in this court to save paper, my lords, in the appeal bundle, either core or supplemental, we don't have a questionnaire that was served by Mrs. Villiers back in August of 2015, but the answers to those questions are set out at page 245 of the core bundle. And Mrs. Justice Parker made an order when eventually her judgment was handed down and the consequentials were dealt with, that provided for Mr. Villiers to provide answers to the questionnaire that was served back in August of 2015. That questionnaire included...
I'm very sorry. 245.
245 of the core bundle, my lord.
Oh, the core bundle. I'm very sorry. So, my fault. I was looking at the wrong bundle. So, yeah. So these are the answers to the questionnaire
That was served by Mrs. Villiers back in August of 15. Those questions include: provide copy tax returns for 2012/13, 2013/14 and 2014/15. And that's the answer you can see at paragraph 2 on page 245. He doesn't have any tax returns. He was asked in paragraph 3 what income he received from the trust in the 12 months preceding the filing of Form E. So it's right to say that there was no request for bank statements that predated the date of the Form E. But there was quite a lot of requests for information that went prior to the Form E. In particular, my lord, he was asked what applications he'd made for state benefits. And on page 246 at the top, he says between November 2012 and February 2014, he was in receipt of job seekers allowance. And so that gives the court an impression as to what his means were during part of the 2013 and 24 calendar year period selected by the judge. Of course, if one goes back, forgive me, I'm dotting about, back to the previous page in paragraph 6, he was asked about his employment contract with Hotel Guru, and one can see the monies that went into his account from that organisation during the course of 2014. And he explained that he didn't get a contract, he's only had the income that he had. And of course, one mustn't forget a very important fact, which in my submission more than makes good the suggestion that Lord Justice Arnold made, is that if one chose 2014, it would have made no difference, because my client was an undischarged bankrupt until the 10th of November 2014. He was only able to work and receive that income from Hotel Guru with the consent of his trustee in sequestration. So for roughly, I don't think it was the full 12 months he was undischarged, but for roughly 12 months of that 2-year calendar period, he was an undischarged bankrupt, and certainly for most of the second part of that 2-year period. And he gave answers to questionnaire. You'll see from page 247 that this is a document dated the 18th of August 2016, and there were, as I understand it, no follow-up questions, no schedule of deficiencies, no applications for third-party disclosure orders that follow the making of that order. That was the information that was provided at the time, and I say it's therefore simply inaccurate to say that Mr. Villiers had provided no information about his financial circumstances during the period in the run-up to the making of the application. And when the judge makes the findings that he does, saying that apart from about £9,000 from Hotel Guru, he was on benefits, that is a perfectly correct finding of fact. And it was open to Mrs. Villiers at any stage after service of this questionnaire to do some due diligence on it if she wished to do so, and she did not. It was suggested that there was no FDR. In fact, my understanding was that Mrs. Justice Roberts did conduct an FDR. Your Lordships have been given a copy of the order she made in November 2016. The telltale sign in that is paragraph 4 of that order, which listed it for trial, said it should not be listed in front of her. My Lord, we made the point in our skeleton.
Sorry, so we read from that what?
Simply, I'm just correcting an error that my name.
No, what's the relevance? Sorry, what's the relevance of her saying she shouldn't be the judge? When I was the first instance judge, when I sat as the first instance judge, if it was a case I didn't like the look of, I quite often said that in order. What significance?
That's not the modern way. Once a case is seized of a judge, one hangs on to it and it's allocated it. Well, Lord, it's a commonplace order. An FDR judge will say, because they have conducted an FDR and have been privy to any without prejudice.
Standard procedure.
So is the privy to standard? Privy to potentially confidential.
My Lord, yes, and in fact, I mean the rules back it up. I can't remember which rule it is. It's somewhere in Part 9. It says in terms.
Yeah.
The FDR judge shall have no further dealings with the case on substantive matters. So, again, I simply just point that out. The last thing, my Lords, relates to paragraph 103 of the judgment, which my learned friend complains about. That is at page, excuse me, 112 to 113. And I make 2 points about that. There was no request following the receipt of the draft judgment for that paragraph to be corrected.
Quite right. Doesn't contain any typos.
Well, my Lord, if
you
one
don't
was...
ask, you make it very clear to the parties. They can't re-argue.
Well, my Lord, if one's seeking permission to appeal... I mean, the curious thing about this case, my Lord, is this. The hand-down was originally going to be on the 11th of March. It was adjourned because there was going to be an application for permission to appeal. And then on the 18th of March, on the adjourned date, there was in fact no application for permission to appeal. And then it only appeared in this court. But ordinarily, if one is saying the judge has got something wrong, and there's an error in the judgment which might go to a permission to appeal, one has I would have thought, a duty to point that out to a judge and say, you've misunderstood my submissions, I'm going to rely on this in the court above.
Yeah, hold on a minute. I think we're at risk of getting distracted here, because as I understand it, Mr. Cayford does not dispute the accuracy of the first sentence in 103. So he doesn't suggest that the judge was factually wrong to record that he hadn't argued that it should reveal the existence of funds. What he objected to, as I understood it, was the second sentence, which, as I understood it, he said it was unfounded speculation on the part of the judge. And are you seeking to defend that sentence?
My Lord, I'm not. I say it doesn't go to any point of fact or relevance to the conclusion. Forgive me if I've misunderstood the point. I'll withdraw it. But certainly, we had understood there to have been a suggestion that the judge had attributed something to my learned friend which he had not said, and I'm just trying, forgive me, to find it in my learned friend's skeleton. I'll come back to it if I need to. But for the time being, my Lord, I can take the point as withdrawn.
I think the only point that I noted was that the subsequent paragraph, 104, Mr. Cayford had the point that, well, that's a bit tough because actually we don't know because the bank statements and what have you haven't been disclosed, so nobody could reach that conclusion. But your point would be, well, actually that doesn't go to any of the points of appeal.
I would know. And of course, if my learned friend wants to make that point, then he must say that the judge made an incorrect finding of fact, and he must seek a retrial. If he's content with the order that's made, assuming there's jurisdiction to make it, then that's neither here nor there. And what I should say that the response, I mean, when one has a non-disclosure in a case, the person on the other party to proceedings has the option of saying, we are going to use the extrinsic evidence that we know to persuade a court that there is money here, there are the resources to make an order. Well, the other alternative is to seek an adjournment and get disclosure from a third-party bank. And the point I make is that there was no obligation on my client to provide details of any bank account between the order that was made by Mrs. Justice Roberts in 2016 and the order that was made at the pre-trial review. And the sad thing is there was no case management in this case between those two dates at first instance. There is no obligation to give updating disclosure unless and until it's ordered by a court. And the court's decision of this case, this court in Immerman, says as much. I'm grateful to my friends. It's page... page 21.
Sorry, 21 or...
Page, forgive me, so sorry. It's page 20, ground 16. And the short matter in relation to that point, my lord, is those instructions we Dawson Common on the 3rd of November indicated if that ground was being pursued, we suggested that there should be a transcript of final submissions in order to see whether the judge's view of the final submissions was right, and no response was made to that. So, my lords, with those, as it were, corrections and clarification out of the way, can I turn to what I say is the first issue, which is what is the ground for making an order under Section 27, it being clear that there is a ground and that it is not simply an ability for the court to make an order whenever it thinks it might be a good idea. My submissions on the correct construction of Section 27 are based in 4 main areas. Firstly, the statutory language. Secondly, the historical context. Thirdly, the authorities, in particular West and West. And fourthly, some general principles of statutory construction looking at the statute as a whole. Now, those are the 4 points, and I do intend to take them in that order, but I will say at the outset that my core submission on this point is that West and West is binding on this court, that although much has changed in the wording of the relevant section between that decision and now, the key temporal aspect of the wording is unchanged, and this court is therefore bound by it. It is binding whether it's from 1954, 1854, or 1994. And my lord, I make the submissions in the order I do, simply to make sure that the court has the proper context for the statutory history to show that there is no material difference on this point, on the temporal aspect of the ground, between the legislation in force then and as it is now. So, my lord, the first area is the statutory language. We've been to Section 27 already, but it's the point that, my lord, the Justice Arnold made. It uses the ground for making the application being that the respondent has failed. That is the ground for making the application. And before the court can make an order under Section 27.6, that court must be satisfied the ground is made out. And it's on that basis and the use of the past tense that I say that the state of affairs, the ground, must be made out as at the date of the application. And my lords, at this point, can I take the court to our authority, I think it's tab 9, case of re M a minor threshold conditions, and it's reported at 1994, Volume 2 of Appeal Cases, page 424. It's to say it's page 284 of the electronic bundle onwards.
Sorry, which tab?
I think it's tab 9.
Thank you.
My Lord, this is a decision that's well known to practitioners in the field of public law children proceedings. For a court to make a care or supervision order, what are known as the threshold conditions, I wouldn't call them condition precedent, but they are grounds that must be made out before the court can make them. And one can see the statutory language, in particular, forgive me, at page 289, where the Lord Mackay giving the lead judgment or lead speech that gives that sets out the relevant section of the Children Act. You'll see reference there to section 31(2)(a), about 6 or 7 lines up, that the court has to be satisfied the child is suffering or is likely to suffer significant harm. And so there are 2 potential times to look at. There's the potential likelihood of future harm, and then there's the is suffering. And the issue in that case was, could a child who had been accommodated and looked after by a family member since the appalling murder of their child's mother by the father, could that child be said to be is suffering harm when by the time of the hearing, the events which gave rise to the application had been long ago? One can see the Court of Appeal's view on page 431 of the report, page 291 of the authorities bundle, opposite letter D. Court of Appeal's view was simply as a matter of statutory language, one needs to be satisfying that it is suffering, present tense, it must be at the time of disposal. And you can see that opposite letter F, i.e. when it decides whether or not to make the care order. The House of Lords took a different view. My Lords, at page 293, one can see 2 passages which have the yellow blobs in the margin, but in particular, the second of those, right at the bottom, in fact, page opposite letter H. The time, relevant date, is the date at which the local authority initiated the procedure. So the court, in that case, is saying, even where there is present tense in the ground, we are going to look at what happened in the past, especially where protective measures have intervened.
Yes, that was to ensure that the statute would operate effectively.
My Lord, yes.
So is it not simply a decision on a different section with different wording in different circumstances?
My Lord, I completely understand that. The point I suppose I would make is one looks at Lord Templeman's speech, page 298.
Before
Sorry, forgive
we
me.
get to that, we could get some assistance, I think, from what Lord Mackay says at 434 at C. Where
Indeed.
he says conditions of that kind would, in my view, normally have to be satisfied at the date on which the order was first applied for. It would, in my opinion, be odd if the jurisdiction of the court to make an order depended on how long the court took before it finally disposed of the case. And you say that applies equally.
Indeed, my Lord, I'm grateful that was, in fact, on one list I was going to draw the court's attention to, and it had skipped my attention. But yes, my Lord, I do rely on that passage. There's also reference to an earlier decision one can see opposite on the same page between E and F, an earlier statute where there's reference there in section 1(2)(a), reference to a child's proper development is being avoidably. And again, the similar decision was made on the facts or on the interpretation of that section. The point that I make is that it is a matter of the language, but also a matter of the statute as a whole, but the language is the starting point. I was going to take the court to page 438 of the report, page 298. Lord Templeman began his speech with reference to the tyranny of language. What I say, my lord, if one looks at that paragraph as a whole, is that I say that the language, or the letter and the spirit of this section point the same way. They point to the need to have made out the ground at or before the date of the application.
Well, what he's really referring to is the modern approach to statutory interpretation, which is you look at the purpose of the statute and you seek to arrive at a purposive interpretation.
My lord, yes.
Or an interpretation which is consistent with the purpose.
And my submission, my lord, is that both the language of section 27 and the spirit of it are both pointing the same direction. The ground must be made out at the time of the application. And my lord, the next aspect, therefore, of this submission, I've dealt with the language. The second aspect is the statutory history.
Well, we're going to stop there if you're going to.
I'm so sorry, my lord. You forgive me.
Point. So you gave an indication at lunch how long you thought you'd be. We've gone off as a result of questions and everything else. Just an indication of how long you think you might be.
I think probably realistically, my lord, an hour and a half.
Okay, thank you. Thanks very much. So we'll adjourn now and start again at 10:30 tomorrow.